Good morning. Thank you for joining me this morning. My name is Kimberly Rivera, and I'm a partner with the law firm of McGlinchey, Stafford. By way of introduction, I was a certified professional in human resources prior to going to law school, and now for the last 20 plus years, I've been doing general business defense litigation. Nobody wants to get sued. That may be the one thing that we can all agree on. Even for business owners, it can be hurtful, not to mention invasive and expensive and risky. You're genuinely trying to do everything right, and along comes somebody, maybe a customer or an employee, sometimes without any warning, and publicly accuses you of doing something wrong. It's been my experience that when a company is sued for the first time, they frequently don't have a realistic idea of what to expect. I've had clients who couldn't understand why I couldn't magically make this meritless case disappear. And contrary to what might be the lawyer stereotypes, most of us really don't want to see our clients have to pay to defend litigation that shouldn't have been filed in the first place. Unfortunately, while I would love to be able to say to the judge, "Judge, plaintiff is wrong, this case doesn't have any merit," and have the judge say, "Okay, dismissed," it doesn't work that way. And in fact, sometimes the case actually really does have some merit. So the point of this webinar is just to give you a high-level overview of what to expect if that day comes for you. The first thing that happens in the litigation process is service of the complaint. The plaintiff has to properly serve you with the complaint. And because you're a business, that means they can serve your agent for service of process that you've identified with the Secretary of State. They can serve you at your principal place of business, or they can serve an officer of the corporation. If they don't properly serve you, you have no obligation to respond, even if you know that the complaint is out there or you came across it through some other means. If it wasn't properly served, you don't have to respond. So you should make sure that the plaintiff has gotten proper service on you. Once you've been properly served, there are a number of things that you have to do pretty quickly. And the first one, of course, is you need to retain counsel. Unlike an individual, a corporation doesn't have the option of representing itself. So you have to go out and find a lawyer, and you need to be careful here because frequently a complaint will name the corporation as well as one or more of its officers or employees. And often the corporation will want to hire one attorney to represent everybody. Seems to make sense. And that's fine as long as everyone's interests align. Unfortunately, sometimes during the course of an investigation, you find out that maybe that employee did do something he shouldn't have done or potentially did something, and you find yourself in a situation where you have to distance yourself from him, either by claiming that he acted beyond the scope of his employment, or the company didn't know about or condone his behavior. At that point, if you have the same lawyer representing both of you, she now has a conflict and she has to withdraw. She can't represent either one of you going forward. You have to go out and find a new lawyer, and perhaps worse yet, the employee can claim attorney-client privilege on anything that he disclosed to your lawyer, and you won't be able to disclose it, and that could hinder your defense. So there are a couple things you can do. There are a few things you can do to try to avoid that conflict situation that's beyond the scope of this webinar, but obviously one of those options is not to have the same counsel. Another option is to make sure that your attorney gives your employee what's called an upjohn warning at the outset of the litigation, which is basically telling that employee that the lawyer represents the company, the lawyer is the company will either claim or waive attorney-client privilege, and if the employee doesn't like that arrangement, he should go find his own lawyer. As long as proper warnings have been given, you should be able to avoid that conflict situation. Another thing you need to do right away is take steps to preserve any potentially relevant evidence. And that means if you have an automatic document destruction policy, you need to stop it. You need to make sure that whatever is potentially relevant doesn't get destroyed. And any potentially relevant can be anything. We're talking about documents and correspondences and emails and call recordings and photographs, and just about anything could be potentially relevant. If it gets destroyed, you not only possibly have hindered your own defense, but you could at some point be accused of spoliation of evidence. And so you want to avoid that situation by making sure that nothing relevant gets destroyed. Another thing that you need to start immediately. You're not going to finish it, but you need to get the ball rolling on your internal investigation to find out if there's any merit to the claims. I've seen situations where corporate officers or owners were just absolutely incensed that anyone would file this complaint against them. It's just wrong, only to discover during the course of an internal investigation that, in fact, there was a mistake made and there actually is merit to the claims. So the sooner you find that out, the better. Is your relationship with the plaintiff governed by a contract? If it is, what does the contract say? And is there an arbitration clause? If there's an arbitration clause, do you want to enforce it? Arbitration is generally a faster, cheaper, less public way of disposing of litigation. So if you have that kind of a clause and you want to enforce it, that's great, but you need to do it quickly, because if you file any other motion with the court before your request for arbitration, you may be deemed to have submitted to the court's jurisdiction and waived your right to arbitration. So if you want to arbitrate, you need to decide that soon. Your early and thorough internal investigation is going to be crucial because it is going to govern your litigation strategy going forward. Are the allegations true, or are they potentially true? Is there a significant risk of negative publicity? How firm a stance do you want to take in fighting this particular litigation, or how badly do you need to settle it? Settling, it's never too early to start thinking about settling it. It might seem counterintuitive initially, and it might actually feel a little bit like negotiating with terrorists, but sometimes it's the best decision that you can make business-wise to settle early, so it's something you should start looking at right away. We'll talk about that a little bit more if we have time. Once you've taken these initial steps, you need to decide how you're going to respond to the complaint. And what you do or do not do at this point in some ways will dictate what you can or can't do later. So you need to be careful in the steps that you take here. And one of the first things that you have to think about is whether there might be a preferable forum available for you. If the complaint was filed in state court, you could potentially remove it to federal court depending on what the allegations are and where the parties are located and how much the damages claim is. In my opinion, generally speaking, federal judges are much better than state judges, and I will opt for a federal forum pretty much any time I have that option. But there is a very, very strict 30-day deadline for removal to federal court, and if you miss it, you're out of luck. So you have to figure that out right away and take the appropriate steps if you can remove it. You also, well, once you've decided what forum you're going to be in, that's when you're going to know how long you have to respond to the complaint, because that varies by court. But your response to the complaint, while there is a deadline, you can almost always request an extension as long as you do it timely. So this deadline is a little bit more forgiving than some of the others that we've talked about. Probably what you're going to do is file an answer to the complaint. And an answer is basically just admitting or denying the allegations in the complaint and then asserting any affirmative defenses that you might have. Affirmative defenses are those on which you bear the burden of proof. I'm not going to get into detail on that right now, but just be aware that there are certain affirmative defenses that are waived if you don't assert them in your answer. So if they're potentially available to you, you need to make sure that you assert them right away, or you might lose that opportunity. You should also determine if you have a basis for asserting an affirmative claim yourself. You might file a counterclaim against the plaintiff, or a cross-claim against a co-defendant, or maybe even a third-party claim for indemnification against somebody that hasn't already been named. If you don't realize immediately that you have these claims, there's always the chance the court will allow you to amend your answer to assert them later, but there's no guarantee of that. So the sooner you can figure that out and get those claims asserted, the better as well. And you also need to look far into the future and decide, if this case actually goes to trial, do I want to have a jury? One party or the other has to request a jury. Otherwise, you're going to have a bench trial in front of the judge. Probably the plaintiff has already requested a jury, but even if he has, if you think you want one, you should request one too, because potentially he could withdraw his request later on in the case, and then you'd be out of luck. So if you think you want a jury, you should ask for one in your responsive pleading. As an alternative to filing an answer, you could file a motion to dismiss. The standard to prevail on a motion to dismiss is high. You can only rely on the complaint and any documents attached to it. and the law. Generally speaking, you can't add any additional facts or evidence to your argument. So here the argument is, for purposes of the motion, you have to assume that the facts alleged in the complaint are true. So the argument will be, even if everything the plaintiff says is true, the plaintiff still loses. For example, if the plaintiff is complaining about an incident that he says occurred in 2014, and he filed his complaint in 2017, and there's a 2-year statute of limitations on the claim, then your motion to dismiss will say, even if we did what he says we did, he still loses because his claim is time barred. Not very many complaints are that facially defective, although some are, but a lot of them are borderline. Because the bar is so high, these motions aren't often granted, but when they are, it is so worth it because you've saved yourself so much time and aggravation and expense. Sometimes the motion might be granted in part, which is also great because it narrows your issues going forward. But even if the motion is denied, it's not really a waste of time because you've now really focused on the issues in the case and you've kind of already created the bones to a motion that you might potentially file later. There is one potential downfall, at least, to filing a motion to dismiss. Under both federal and state rules, the plaintiff can amend the complaint at any time without leave of court until a responsive pleading is filed. A motion to dismiss isn't considered a responsive pleading. So you have the potential, if you file your well-reasoned, thoughtful, well-researched motion to dismiss, that you've now done the research that the plaintiff should have done but didn't do, and laid out the roadmap for the plaintiff to amend his complaint and file a stronger, better one. So you need to think about that if you think that's a potential issue. One possible alternative is to go ahead and file your answer and then file a motion for judgment on the pleadings, which is very similar to a motion to dismiss, but now because you filed your responsive pleading, at least the plaintiff would have to get leave of court if he can get it to amend his complaint before he can change any of his allegations. Assuming the case makes it through the pleading stage, you now enter the dark world of discovery, which is probably the most hated, invasive, frustrating, time-consuming part of litigation. The scope of allowable discovery is very broad. With the exception of attorney-client communications and work product, the standard is anything that is reasonably calculated to lead to the discovery of admissible evidence. And of course, what you consider to be reasonably calculated and what the plaintiff considers to be reasonably calculated is pretty much never going to be the same. And that can lead to discovery disputes, which can be tedious and expensive, and if the parties can't work it out, it might lead to having to file motions with the court. And I will tell you right now that courts universally hate discovery disputes. They hate them. So if you get to the point where you actually have to get the court involved, you want to be the party that looks like you're being the reasonable one. If you're not that party, you're not going to win any friends with the judge. But it's always best, if you can, for the parties to work out the discovery disputes between themselves without getting the court involved. Discovery can take many forms. There's several kinds of written discovery. The first is written interrogatories, which is a series of questions that the plaintiff might serve on you, and you have to provide verified responses to those. The number that they can serve on you is limited under both state and federal rules. Another form of written discovery is requests for admissions. Requests for admissions is a series of statements that you're supposed to either admit or deny, and you have to be very careful here because if you admit something, it's admitted for all purposes. And if you fail to timely respond to the requests for admissions, they are all deemed admitted for all purposes, and that might be all the plaintiff needs to win his case. So if you're served with requests for admissions, you need to pay prompt and careful attention to responding to those, and there is no limit to the number of admissions that one party can serve on the other. You're almost certainly going to be served with written requests for production of documents, and again, documents is an oversimplification. This can be e-discovery, electronic discovery, discovery of databases, policies and procedures, internal emails, text messages, correspondences, notations on a calendar, virtually anything that's tangible, if it's potentially relevant, is fair game in written discovery. So requests for documents is probably the most invasive part of discovery, and even a respectable, upstanding business probably has documents that it would prefer not to share outside of its walls. There are a few steps you can take here to try to protect your privacy. Sometimes you can reach a protective order with the other party, but generally speaking, this document productions is just one of those bitter pills that you have to swallow when you're involved in litigation. In addition to the written discovery, you might be served with notices of deposition. The plaintiff can either serve a notice of deposition asking for the deposition of a specifically named person within your organization if the plaintiff reasonably believes that that person has firsthand knowledge relevant to the claims. More likely, though, the plaintiff is going to serve you with a notice of corporate deposition. And what that is the plaintiff is going to identify the topics on which he seeks deposition testimony, and you as the corporation will determine what witness or witnesses are most knowledgeable to testify to those topics. Again, the plaintiff is probably going to go way beyond the scope of anything that you think is reasonable, and this could also lead to a discovery dispute. But generally speaking, when those requests, those deposition notices are properly made, those depositions are going to go forward. The good news is you get to serve the same kind of discovery on the plaintiff. So that is your opportunity to find out if the plaintiff really has any evidence to support any of his claims, or any of his damages, or what his damages are, or how much they are. It might be surprising how often you get to this point in the litigation only to discover that the plaintiff doesn't really have any evidence of his claims, which leads me to my next topic, which is motions for summary judgment. A motion for summary judgment is yet one more opportunity for you to try to get rid of this case without going to trial. Unlike a motion to dismiss, which relies strictly on the pleadings and the law, a motion for summary judgment relies on all of the evidence that was collected during the course of discovery. The standard on this motion, while still high, is much easier to meet than on a motion to dismiss, and these motions are much more frequently granted. The argument here is if we look at all of the available evidence, which is responses to admissions, responses to interrogatories, documents that were produced, deposition testimony, and construe it all most favorably toward the plaintiff, there is still no genuine issue of material fact, and you are entitled to judgment as a matter of law. So, for instance, the plaintiff is claiming that you violated the Federal Telephone Consumer Protection Act because you called his cell phone without his permission. In the documents that you produced, you show that you never dialed that phone number. In the documents that he produced, or in his deposition testimony, he doesn't really know for sure who dialed his phone number, he just knows that somebody did. This is a perfect summary judgment case because there is no genuine issue of material fact. The evidence doesn't support the plaintiff's claims, and that's a claim that should be thrown out on summary judgment. Again, they're not all that easy. Some of them are, but this motion is going to be much more frequently granted than your motion to dismiss. And again, sometimes it's partially granted. Sometimes you can get some of the claims thrown out, and if you can, that's great because it really narrows the scope for trial. And again, if your motion for summary judgment is completely denied, it's not a waste of your time and effort because now you've done all your research, you have looked at all of the evidence, you've narrowed in on the weaknesses and strengths of your own case and the weaknesses and strengths of the plaintiff's case, and you have really set yourself up for trial preparation if that's going to be your next step. Very few civil cases actually go to trial. It's not like on TV where they file a complaint one day and the next day they're in the courtroom. Very few cases go to trial. Most of them are thrown out on a motion to dismiss or a motion for summary judgment, or they settle. If you're one of the rare cases that actually goes to trial, be aware that a jury trial is longer and more expensive than a bench trial. With a jury trial, you have to prepare for selecting the jury, questioning that you're going to conduct in selecting the jury, You have to prepare jury instructions and jury interrogatories and jury verdict forms. You have to go through the selection process. You have to wait for deliberation. A jury trial is easily going to add a day or more, even to just a short trial. So it might be well worth it to have a jury of your peers, but it's just something to consider. If you decide that you don't want to go to that added time and expense, and the plaintiff hasn't requested a jury, you can have a bench trial. A bench trial is much less expensive and it's much faster, but you're at the mercy of the judge. So that decision is going to be largely based on who your judge is and whether you trust him or not. Whether you have a jury trial or a bench trial, or whether your case is decided on a motion to dismiss or a motion for summary judgment, the losing party has the right to file an appeal. So if you're the losing party, you have the opportunity to have a three-judge appellate panel look at your case, and you can tell that panel what you think the trial court did wrong, and have three judges review it and see if they agree with you. If you are the winning party and the plaintiff is appealed, there's always that looming possibility that the appellate court could reverse the decision and potentially even remand for a new trial. There, again, is a very strict deadline for filing an appeal. It's 30 days from the date of judgment. If you miss it, you're out of luck. You don't get any extensions of time to file the appeal. An appeal will, of course, extend the litigation, but the good news is we don't conduct discovery during appeals, and there is very little, if any, motion practice that goes on during the appeal. We touched on settlement a little bit earlier on, and I just want to touch on it again. From the filing of the complaint throughout the litigation, settlement is something that you need to consider and reconsider over again as you learn more and more about your case and about the plaintiff's case. If there's potential merit to the plaintiff's case claims, of course you're probably going to want to settle the case, and you're going to want to do it sooner rather than later. Some statutory claims have attorney fee shifting provisions, which means if you lose, you may well have to pay the plaintiff's attorney's fees, and that can be far more than any actual damages that they might have suffered. So you really need to be aware of whether there's an attorney fee shifting provision involved here, because the longer the case goes, the higher the attorney's fees are going to be on both sides. If there isn't any merit to the claims, you still need to consider whether you want to settle or not. I hate rewarding a plaintiff for filing a meritless case. I'm sure all of my clients do as well, but again, sometimes it's the best business decision you can make. Some courts will require you to go to mediation. Virtually any court is going to be open to mediation if the parties want to go to mediation, and will probably provide you with a mediator for free if you want to use the court's mediator. If the parties haven't been able to settle and you have a plaintiff that just does not see the weaknesses in his case, an impartial third party such as a mediator can be invaluable in helping either side see the weaknesses of their case, and then that can go a long way toward encouraging settlement and perhaps reaching it. So while settlement can be distasteful, it's often a far more prudent route to go when it comes to expense, risk, and exposure. So that's my 100,000-foot view. I'll open it up to questions if anybody has any. The question is, will the website be available for download? And I understand that they'll be available within